I often hear people say lawyers and paralegals are too expensive, you can do it yourself, it's easy. Usually that advice comes from well-meaning friends or so-called experts who will not take responsibility when the things go wrong. And once you have lost your case, those same people are nowhere to be found. They are not accountable for the bad advice they gave you, and you're left alone, dealing with the consequences. A landlord came to me after they had already lost the case at the Landlord and Tenant board. They believed it was a straightforward case because the tenant was causing constant noise and disturbing our residents. So we filed the notice, served it, and thought showing up at the hearing would be enough. But here, what they didn't realize, in those cases, the burden of proof is on the landlord, not the tenant. You have to prove the disturbance happened with the evidence. No accidents reports, no recordings, no written complaints from the neighbors, no clear timeline, nothing. At the hearing, the tenant challenged everything and simply denied all the allegations. He didn't provide any evidences, just stated that events never happened. And he was right to point out that it is not his responsibility to prove good behavior. The burden of proof rests entirely on the landlord to establish the misconduct of a tenant. The adjudicator had no choice but to dismiss the application. Now, instead of resolve the issue, the landlord is stuck in appeal. An appeal is more complicated, more stressful, and more expensive. If I had hired a paralegal from the beginning, it could never happen. As a licensed paralegal, I make sure the notices are correct, deadlines are followed, and your case is strong and supported with strong and proper evidences. Don't gamble with your property. Call me before you file, not after you lost your case.